Hi friends, today I want to talk about three questions. I have got no hesitation in my mind that these three questions have been widely misunderstood by various people, especially the common people. Recently, one woman came to me. She came to me and she asked me these three questions and she wanted to know more about those answers and those details. I explained everything to her, and at that time I realized that not only she, there are many people, women, men, and n number of people, professional, unprofessional, non-professionals. Many people do not know about the provisions of various acts and laws in connection with these three questions. The first question is, what are the options that are available to a person if he or she marries a person whose previous marriage is already in existence? I give you a clear example. A woman is there and she has got married as per the traditions of Hindu Dharma under Hindu Marriage Act with a man, that is the husband. Later she comes to know that the husband with whom she has married, his previous marriage is also in existence. The husband has not taken any divorce or has not obtained any decree regarding annulment or nullity from the previous marriage, and the previous marriage is in subsistence. At that time, the husband has gone ahead and performed the second marriage, in spite of the fact that the previous marriage is also in subsistence. Now, the wife is cheated, the second wife is cheated. What are the options that are available to the wife who has been cheated by the husband whose previous marriage was or is still in subsistence? First, whether the woman can go for divorce. The answer is no. She cannot go for divorce. We have to understand the difference between what is the meaning of divorce under Hindu Marriage Act and what is the meaning of annulment, that is nullity, under Hindu Marriage Act. Annulment, that is nullity, is way different than the concept of divorce. Unfortunately, these two terms are widely misunderstood by many people, common people. They do not know what is the meaning of annulment, nullity, and they do not know the meaning of divorce. So they use it interchangeably, and sometimes the petitions are filed. Even though the marriage demands annulment, the petition filed is for divorce. And when there is a demand for divorce, technically, legally, the petition which is filed is regarding annulment or nullity. So we have to understand the difference between these two terms. So when there is a marriage of the husband which is still in subsistence and the husband marries again with another woman, then the second woman can go not for the divorce but for the annulment of marriage, that is the nullity of marriage. She can make an application to the court under section 11 of Hindu Marriage Act and she can get the decree of nullity for the annulment of marriage, and she can remarry again with somebody else. This is the provision. Now, what happens if the woman does not file an application under section 11 of Hindu Marriage Act and does not get the decree of the annulment of marriage, and still she marries yet another husband or person? Will she get arrested? No. The law is very clear on this particular point. If the previous marriage of the husband is in subsistence, then if the second wife comes to know about the previous marriage of the husband which is there in subsistence, then the second woman, in spite of filing a petition under section 11 of Hindu Marriage Act and getting the degree of annulment, in spite of that she can directly marry somebody else. She will not get arrested. Why? Because the Hindu Marriage Act clearly talks about one thing. When the previous marriage of the husband or the wife, whatever it may be, when the previous marriage is in subsistence and the husband marries again, then the second marriage is as good as a zero marriage, null and void. And it is null and void ab initio. So there is no need to go for filing a petition to get the decree of nullity of marriage for the annulment. It depends upon the woman. If she wants to have the decree, she can file the petition. If she does not want to file the petition, it is not compulsory to her to file the petition. She can straight away get married to somebody else because she has been cheated. The previous marriage of the husband is in subsistence. So there is no need to file the petition. But if she wants to file the petition, she can go for that. It is optional. So she can get married. So here the provisions of divorce are not attracted. The provisions of annulment, that is nullity, under section 11 are attracted. Second question which I would like to talk about is which is widely misunderstood by many people, and that question is, if the marriage falls within the ambit of child marriage, either the husband is a minor or the wife is a minor. If any one of the spouses is a minor, not attending the majority, what is the option that is left with the other party? I give you a simple example. Husband is there, he marries a woman. Later he comes to know that the real age of the wife was hidden from him and he was cheated by the family members of the wife, and the family members of the wife told husband at the time of marriage that the wife is major. Later the husband comes to know that the wife is not major at the time of marriage, she was minor. What is the option that is left with the husband? Because husband has been cheated because the wife is minor. Whether the husband can go for the remedy of divorce. Again, he cannot get divorce because the provisions of divorce are not at all applicable to the current case. The husband can file a petition for the annulment of marriage by decree of nullity or for the nullity of marriage, and he can get the decree under section 12 of Hindu Marriage Act, and he can get the marriage annulled by a decree of nullity. That is available to the husband, but he cannot go for divorce. So you have to file a petition under section 12 of Hindu Marriage Act because the husband has been cheated. Now, under what section? Under section 12, subsection 1, clause D of Hindu Marriage Act. There is one more provision which is available to the child, that is the wife or the person who is minor. And what is that provision? There is one act, Child Marriage Prohibition Act. The minor person, that is the wife in this case, she can file a petition under section 3 of Child Marriage Prohibition Act and get the marriage annulled by decree of nullity. Now if the wife is itself a minor, somebody on her behalf can file the petition and get the marriage annulled by decree of nullity. These are the two options, but certainly you cannot go for divorce because the marriage itself is void. The marriage itself is illegal, so you cannot get divorce. You can get annulment and you can then remarry with somebody else. But without getting the marriage annulled, if you remarry again, then that will create hurdles for you and there will be criminal case which will be filed against you. Third question, what if the wife of the husband is pregnant before the marriage was solemnized? Now she was pregnant not by the husband, by somebody else, and the husband comes to know about that subsequently in future. Now whether the husband can go for divorce? The husband cannot go for divorce again. Why? Because the provisions of divorce are not at all applicable. The provisions of annulment of marriage are applicable in this current case also. There is a difference between annulment and divorce. So under section 12 subsection 1 clause D of Hindu Marriage Act, the husband can file a petition for the annulment of marriage by a decree of nullity because the wife is pregnant before the marriage by somebody. So the child which is going to born is not a child of the husband but the child of somebody else, and that's why the husband can go for the petition for the annulment of marriage by a decree of nullity. That is possible to the husband. So widely speaking, people have failed to understand that divorce is something different and annulment is something different. Three questions which I have talked about deals with the annulment of marriage. The marriage itself is illegal. The marriage itself is void. The marriage is zero. That is child marriage. That is the previous marriage of the husband and wife was in subsistence. Again, the third provision that the wife is pregnant by somebody else. So these points, these facts attract not the section 13 of Hindu Marriage Act, that is divorce, but they attract section 12 and section 11 of Hindu Marriage Act for the annulment of marriage. Suppose in a case which is a fit case for the annulment, the client files a petition for the divorce. Obviously the divorce cannot be granted. In similar fashion, if the facts of the case demands filing of petition for divorce and the client files a petition for the annulment of marriage, it cannot be granted. You have to go for the divorce. So there are two different terminologies. Divorce is something else and annulment is something else. Child marriage, you can go for annulment. Previous marriage in subsistence, you can go for annulment. Pregnancy before marriage of the wife by somebody else, you can go for annulment. These three factors do not attract divorce provisions, and if you file so, you will not get divorce. The scope and ambit of divorce is something different, and the scope and ambit of annulment of marriage by a decree of nullity is something different. In annulment of marriage, the marriage itself is declared as void ab initio, as if the marriage did not take place. The marriage was not fit to take place. That is the purpose. And that's why the ambit of the section 11 and 12 for the annulment of marriage by a decree of nullity is different. That is void marriage and voidable marriage. So please do not confuse these two terms together. I have seen many people who have gone for divorce even though their case is fit for the case of annulment. So we have to understand the differences between these two terminology and go for the remedy. In the coming videos, I will talk more about the further provisions of annulment and divorce as far as Hindu Marriage Act is concerned. In India, we have got different religions. So as per the religions of the world, they have got different laws. So I have talked about the Hindu Marriage Act. If both the husband and wife are Hindus by religion. So in the coming videos, I will talk about later and further provisions of the marriage. Thank you so much. Thank you.